My name is Robert Blackman. I'm a patent attorney and a mechanical engineer. I'm a named partner / member at Merrick, Blackman and Voorhees, and I've been working in the patent field since I was a patent examiner back in 1988. I wanted to give you a quick introduction to patents, trademarks, and copyrights today. I can't go into all the legal ins and outs of the field, but hopefully give you a good background from which you can seek out an attorney or figure out what needs you may have. For this lecture, I'm going to ask you to pretend that you have just come up with a new company called Yellow Bus Company, which has invented a unique pencil which you have named Big Yellow. You're now going to see how the different parts of intellectual property come into play as you go about trying to get protection for your new pencil. The first field that you may want to look into is patents. Patents protects the invention or the scientific background behind the pencil itself. Perhaps you have a new formula for the graphite of the pencil, or maybe you have a new composition for the eraser, or maybe just a new mechanical fastener between the pencil and the eraser. These are typical types of patent protection that people get. There's other kinds called method patents, which may protect how the pencil is assembled or what may be something that you do with the pencil. In order to get patent protection, you have to file with the United States Patent and Trademark Office. Protection is good approximately 20 years from the time that you file your patent application, and the patent goes through the patent office and becomes a patent. The only protection you get, for the most part, is from the claims at the end of the patent. This is a reason that many people hire patent attorneys to help them out. First, only a patent attorney can represent somebody during prosecution before the patent office, but they also have a lot of background and experience in drafting these claims so they can protect you to the utmost possible. Another way that you may want to protect yourself is trademarks. Trademarks, unlike patents, have a common law aspect, meaning there is some portion that is automatic. But trademarks are designed to protect the name of your company, the name of your services, the name of the products that you produce. For example, here the Yellow Bus Company is the name of your company. You may want to protect that through a trademark. A different type of protection is the trademark itself, Big Yellow, for the name of the pencil. The trademark law is designed in as much to protect the buying public as it is to protect your company. And therefore, there are all sorts of other considerations that come into play with trademarks. Patents you can buy and sell just like you can buy and sell a house. However, trademarks are often tied to the services that are provided or the goods themselves. So it may be that if you wanted, a banana company came up and said, hey, we want to buy your title, your trademark, Big Yellow, there may be very little rights that transfer over, but you could be paid to abandon your use of the mark. However, there are considerations that the buying public wants to be protected. So when they see the name Big Yellow, they know the quality level is associated with your product and maybe even your company. So when you buy, for example, a Coca-Cola product, you know what the quality level is, and you don't have to guess as much. Whereas if a shoe company, bought the title Coca-Cola from Coca-Cola, you might not know what the quality level could be. The trademarks you file with the trademark office to give constructive notice across the entire country that is your name. You can file before your name is in use, but at some point you will have to sell the goods or services in commerce, meaning between the states or between a state and another country, in order to complete registration. Copyrights also have a common law protection. Copyrights protect works of art, not necessarily paintings only. They could be books, sound recordings, blueprints, computer programs, etc. Copyrights, when you file, as soon as you reduce it to a particular medium, such as in print or on a computer, you have some copyrights automatically. These are called your common law rights. You may want to register with the Copyright Office because it gives you several advantages. First, in order to sue somebody on a copyright, you will most likely need to have a registration in place. Also, you can get statutory damages. That is, the judge can assign damages against the losing party in an infringement case, the infringer, without you having to prove that he was directly responsible for your losses. For example, if he's selling your pencils, you don't have to prove that he's either made so much money off of it or that he's caused your losses. The judge could assign statutory damages against the defendant. And that's the difference between